Thank you very much. And as I just indicated, we are going to be recording this, and it will be on the Lee Bar's YouTube site down the road. So I want to go ahead and introduce Christy Scott. She is the founder and managing shareholder with Lightpath Law, PA, and she concentrates her practice in church law, business law, labor and employment law, and civil and business litigation. Christy has an AV preeminent rating with Martindale Hubbell, has been named a rising star by Thomson Reuters Super Lawyers magazine since 2019. She was selected as a National Black Lawyer Top 40 Under 40 in 2020 and 2021. She was featured in KNOW Fort Myers magazine in 2020 and was recognized as a leader in the law by the Florida Association for Women Lawyers in 2017. Christy is an adjunct business law professor at FGCU, where she has taught since 2018. She's a frequent public speaker and heavily involved in the community. Christy is a member of the Fort Myers alumni chapter of Delta Sigma Theta Sorority, Inc., a public service organization. And on a personal level, I discussed with Christy her doing this presentation regarding staying professional in difficult mediations, because I had the great good fortune of mediating a case that was incredibly difficult, and she just blew me away with how professional she was. So this is a very logical fit. Okay, Christy, if you'll start us off, thank you very much.
Good afternoon, everyone. As Anne said, I've had the pleasure of mediating cases with her, and I oftentimes attend mediations, even as recently as yesterday, attending what I would consider to be a difficult mediation. And so I'm very honored to have been asked to speak today and to kind of give you my thoughts as it relates to this topic. So we'll be talking about how to stay professional in difficult mediations. And I've broken down this presentation into 3 parts: things that you should do before the mediation, things that you should do during the mediation, and then after the mediation. So when we're talking about what should happen before the mediation, let's get started. So before the mediation, I think that it's super important that you have communications with your client and that your client knows exactly what to expect. So, so whenever you are talking to your client, there are certain things that you should say prior to the mediation. You should also consider selecting a mediator who you're going to choose, the mediation statement, considerations regarding who the opposing party is, as well as if there's been any difficult personalities and things of that sort, what communications you're going to have with the mediator prior to mediation, as well as determining what your mediation strategy is going to be, and determining whether you're going to use any visual aids and opening statements and things of that sort. So I went through that really fast. I want to caution you, let you know that I won't be speaking that quickly throughout this presentation. We're going to break these things down, but just wanted to kind of give you a list of things you should consider prior to the mediation. So let's go into explaining to your client what is mediation and what the process is about. So I think that oftentimes, because we are in the legal arena, like, to us, the concept of mediation is not foreign, but to a client it's extremely intimidating. They haven't gone through mediation before, and they may not know, may not be familiar at all with the mediation process. So you want to make sure that you talk to your client and tell them what they should expect. Oftentimes, mediation is required as a part of our state or federal cases. And so the client should know that this is a required meeting that is going to be between the opposing party and their attorney, and obviously that you'll be there to assist your client. And then also you should explain to them what a mediator is. The way that I like to explain it is to say that a mediator is a person that is trained at getting parties to resolve disputes. Oftentimes the mediator has a legal background and things of that sort, but you want to explain to them that the mediator is someone that's trained at getting the parties to resolve the dispute. And then I literally tell my clients exactly what to expect. So I go into the fact that when mediation starts, the mediator is going to give, kind of an opening, and I tell them what I expect the mediator is going to say. I tell them that I think that mediation is a good process. I'm not telling you what to think, but I do think that mediation is a good process, and I tell them that mediation is going to benefit us regardless of whether we settle the case or not. And the reason that I think that mediation is beneficial is because it will kind of give them a little sneak peek of some arguments that the opposing party is going to make in the event that the case doesn't settle. And so I think that that's helpful information for our clients to know. And then I even tell them, that at some point we're going to be separated. We'll be separated from the opposing party, and that the mediator will go back and forth. And so when I'm explaining to a client what mediation is about, I literally go through, exactly, kind of what I expect will happen. That the mediator is going to make their introduction, that the mediator is going to talk about confidentiality, and I start talking to my client about confidentiality as well. So I think that initial conversation with your client is a very important one, because you want your client to understand what they're going to be walking into, if you will. Um, and so, speaking of confidentiality, I take that opportunity to tell my clients that mediation is confidential. And I feel that having this discussion prior to the mediation is important, because I have had a situation where a client brought someone to mediation, and we all know that that's a no-no unless you've gotten consent from the other parties. And so, constantly learning from practicing, I find that it's important to talk to your clients to say, look, mediation is confidential. You're not going to be permitted to bring anyone. You're not permitted to, share what happens at mediation with anyone. And so I think that those are conversations that you should have prior to the actual mediation. And so that brings us to the next point, which is regarding selecting a mediator. And so you have a lot of options here between you and whoever the opposing attorney is. It's up to you all to choose a mediator. And so there's different options. Of course, you can go through the court-ordered mediation process, and that is pretty cost-effective, and they can assign you a mediator. And so depending on the amount that's in dispute and what the dispute is about, you might find that that's appropriate. I have also used what's known as like flat rate mediators, and I found that that's effective, especially in some like lower disputes, like amounts like I would say less than 15,000. You might want to choose a flat rate mediator, and so those are available. And basically, the way that works is that they basically just charge an amount for the whole day. So, like I've seen them as low as like $250 for the day, and literally those mediators will just be there with you all day if it takes all day, but they charge you just that flat rate. And so that can be cost effective. And then last but not least, you can use some of our local attorneys and local hourly mediators, where they just charge you by the hour, and oftentimes they split the cost between the parties. And so those are some options you can consider. Of course, you should also think about what your dispute is about and what the mediator specializes in. So you can go online and read bios for mediators, and mediators often will tell you, that they like to mediate certain types of disputes. And so you can consider all of those things when you're selecting your mediator. Next, in in still thinking about how you go about preparing for mediation, you can consider whether you want to prepare a mediation statement. I often prepare a mediation statement, and it's basically just correspondence to the mediator, to just tell them about the case and things of that sort. But sometimes I don't. And so there's a couple of things you have to think about. Obviously, if your client is trying to keep their legal fees low, then maybe it might be more appropriate for you to just give the mediator a call. But and in certain cases, if they're really easy and really straightforward, you might decide that you don't want to prepare a mediation statement. But if you do decide that you want to prepare a mediation statement, I want it to go over the things that I often include in my mediation statement. So basically, the way that I do it is I prepare it just as a letter to the mediator. And I tell them if I want them to keep the statement confidential. So, if you're sharing this information with the opposing party, then great. But, I think that you should always tell your mediator if you want them to keep something confidential. And so I often start off by saying, this is something that I've shared with the opposing party, or this is something that I want you to keep confidential. I often will tell them who I'm expecting to be at the mediation. So, this is super important if you have a business client or a client, maybe like a community association or something like that, that you go ahead and explain to them that, who with the business or who with the community association is going to be attending. And then also who I expect will attend on the opposing side. And then I will give a summary of the matter. Now, can your mediator get online and actually, research for themselves, the complaint and answer and all those things? Well, yeah, of course they can, and they very well might. Most mediators will look at the pleadings, but I like to explain in layman's terms what the case is about. And that way, the actual mediator can have kind of like a short summary of like, okay, this is why they have scheduled this mediation. This is what the case is about. And so I will give a summary, and I will also oftentimes give my client's position, and so that way the mediator in just a couple of pages can easily find out what the case is about. If there's a timeline for super complex cases, that might also help the mediator in mediating the case. And so that's something that you might want to consider. I also tell my mediator about any prior settlement discussions. If you have almost settled the case in the past, then I think that's important information for the mediator, and it also helps us with setting expectations. And so, if I know that my client is wanting a certain dollar amount or things like that, sometimes I determine whether I should share that with the mediator or not. But there's the mediation statement, and I think that that's the way that you start out professionally. Is we're talking about how to be professional. I think that if you have the ability to come up with your mediation statement prior to that, is a good way to start off in a professional manner. And then, like I said, sometimes, if for whatever reason, we don't prepare a mediation statement, I will pick up the phone and call the mediator. And I'll often go over kind of like these same things. So if you don't have time for a long letter to your mediator, maybe just pick up the phone and give them a phone call and say, look, we have this mediation scheduled. This is what the case is about. These are kind of some expectations. And we have or we haven't had settlement discussions before. And most mediators will probably find that that is effective as well. Now, the other thing that you need to consider whenever you're preparing for mediation is you need to consider who the opposing parties are. If you've had communications with maybe the attorney, the opposing attorney, and if those have been kind of argumentative communications and things of that sort, I think that those are things that you should keep in mind. It might even be something that you want to share with your mediator. And so I think that whenever you're dealing with difficult personalities, you have to consider that before you ever walk in the door, because frankly, it may have an impact on how you conduct yourself. It might have an impact on just the flow of the negotiations and things of that sort. And so I think it's important for you to consider the overall conflict and the parties that are involved. So also prior to mediation, I go ahead and I start thinking about the mediation strategy. I think about, okay, what do I think that this case is worth? I had that conversation with my client so that I can just set expectations with my client. So my client's not expecting to walk away with $1 million if I think that the case is valued at 20,000, for example. So I set those expectations and even do a little bit of research regarding what you might be able to, what type of damages, for example, you might be able to obtain if you were to win at trial. And that way that you can use that information to assist you with your strategy at mediation. Make sure that you understand what your client's desired outcome is. I think that it's important that we, just have good and straightforward communications with our clients. And so talk to your client about, look, how do you want this to end? And figure out whether there is any disconnect between what you expect and what your client expects. In determining your strategy, figure out if you have a settlement range, figure out who has the attorney's fee exposure. I mean, it might be both parties, or it might be, one party has a greater attorney's fee exposure. And so I think that you can use that information in order to determine whether and how you negotiate. And finally, consider what your client's costs are, because oftentimes your client might be trying to recoup their costs as well as damages. And so you should think about that whenever you're determining, what type of outcome and what type of strategy you're going to use at mediation. And so to that end, I often prepare my opening statement prior to attending the mediation. So if you prepared a mediation statement, that is helpful in preparing your opening statement. I've even oftentimes kind of used the mediation statement as my opening statement. And then sometimes I've done things a little bit different. Depending on the actual case, sometimes I put together a PowerPoint, just like I have a PowerPoint for this presentation. I have used PowerPoints at mediations as well, especially when it's very difficult issues. Maybe if there's like a lot of parties, or just issues that might be hard for the mediator to follow, or hard for the opposing parties to follow, I find that presentations are helpful. And then other times I'll just, kind of be, more casual and just kind of read a opening statement. But specifically, if you have a high dollar case, or a case that's, difficult to understand, or a lot of dates and things of that sort, you might find it helpful to just put together a PowerPoint presentation. And obviously, if you do that, then I think that's a professional way of communicating and handling your case. So those are all the things that I think about before the mediation. So I've had my client meeting, I've selected the mediator, I have kind of put together my mediation statement, and then put together my opening statement or presentation. Now, I have had mediations where the opposing party may say, hey, I'm not interested in sharing opening statements. And, every case is different, and you all are free to do whatever you like, but I'll tell you my 2 cents, which is that I think that having the opening statements is always helpful. And the reason why I think that it's helpful is for your client, it will help your client understand, that their position is not the only position. It'll help them understand that, look, there's an opposing party that has a um, you know, completely different facts maybe or legal arguments, and your way isn't the only way, that this is indeed something that's in dispute. And I also think that it's helpful because it helps you learn about the opposing party's position. They will often say something that maybe you didn't know. And while you can't use, what's said at mediation um, against that party per se, it might still, drive you to do some discovery or something like that in the event that the case doesn't settle. And so I think that having those opening statements is helpful at mediation. So now that we're fully prepared for the mediation, let's talk about what you should do or consider during the mediation. So during the mediation, it's important for you to maintain your professionalism, even if you are dealing with people with difficult personalities. Okay. So, I think that a person's professionalism and the way that you conduct yourself is extremely important at all times. You have to remember that you have a client that you're representing. So, certainly, you want to advocate for your client, but you also want to make sure that you conduct yourself in accordance with Florida bar rules and in a professional manner. And so different things that I try to do during the mediation that I found to be helpful include um, listening to the opposing party during their opening statement. So I tell my clients that, look, during the opening statement, they are probably going to say some things that you disagree with, but let's not interrupt them, and things of that sort. And so I think it starts there. Obviously, you're going to let the mediator give their kind of introduction to the mediation. And when the opposing party is speaking, you should not speak, even if you disagree. Let them share their perspective. And then, of course, whenever you have an opportunity to respond, then you can address some of the things that they said that maybe you didn't agree with. And then, I think that having the opening statements at the start of mediation and allowing everyone to share their perspective without being interrupted is a good start. And especially if you are having people with difficult personalities, you can let your mediator know, if the mediator doesn't suggest it, that it's a good time to separate the parties. And from there, your mediator is going to be the one that is going back and forth between the parties. Now, I think that it's really important to have appropriate expectations with your client. So, when you're, the way that I handle my negotiations is I tell my clients that, look, the actual amount that we send to the opposing party is completely up to you, client. I can share my opinions and strengths and weaknesses of our case and things of that sort, but I'm not actually going to tell you that we should send this number. I think that the settlement decisions is always up to the client. And so to that end, I think that if you want to get the matter resolved, it's important for you to have that trust with your client, and for them to understand that the final number that might be on the table is up to them. The other thing that I like to keep in mind during mediation is that, for the most part, we can come up with whatever settlement agreement that we want. Like, it doesn't necessarily have to be just money, to the extent that the dispute involves, that something else needs to happen. We can be really creative in the settlement agreement. And so you want to share that with your client, depending on the type of case that it is. So, for example, if the case is about real estate, and maybe let's say that they're fighting over who should have occupancy of a property, you can negotiate that one of the parties, makes repairs prior to, that doesn't have anything to do necessarily with money. But I think that one of the benefits to mediation and settlement negotiations is that, anything that's legal can be negotiated. So to that end, you want to think about, is this settlement offer in the best interest of the client? And I mean, truly, truly in the best interest of the client. And you want to make sure that, while your client has the ability to either accept or not, that you are really thinking about, is this in my client's best interest? And that you share that opinion with your client. So, for example, if you think you have some really big weaknesses in your case, and so you possibly get maybe a somewhat decent offer, share with your client, look, they're offering this amount and we do have some issues with our case. And so we might want to consider accepting this or not, explain the potential risk or versus the potential rewards to your client. And so that way your client can make a really informed decision about whether to settle or not. And this note that I put about thinking inside and outside of the box, I've kind of already gone over, which is basically just thinking about the fact that it's not just about money. There are other resolutions that you might want to consider or include in your negotiations. And then, I just wanted to talk about generally how to maintain your professionalism. I've been in a lot of mediations where we put forward a number and then the opposing side comes back and they say, oh, we want to offer, $1,000 or something that I might consider to be just completely unacceptable. So if that's the case, make sure that you maintain your professionalism. And I think that this kind of goes back to setting expectations with your client as well, because, I tell my client that, look, they might come back with an offer that we think is just completely, insulting. And if that's the case, that's okay, because I think that mediation is not about where you start, it's about where you finish. So, you can start out, super far apart from each other, but it's not about where you start, it's about where you finish. And so, I think that how you respond, what your demeanor is and things of that sort are very, very important during mediation. And, we haven't talked about this so much, but, it's important for you to negotiate in good faith, right? Like, I think that we have a responsibility to come to mediation and in good faith, try to see if we can get the matter resolved. And so, operate in good faith, put forward, numbers that you think are reasonable and things of that sort. So we're going to have a question and answer session here in a moment. And so if you have any specific questions about what else you can do to maintain your professionalism, I'm happy to go over those. But I think that that just your overall demeanor and your communications with your client about what you might be able to do to get the case resolved are the most important things to consider. All right. So, what about after mediation? Okay. So, let's say that, regardless of how mediation went, maybe you all were able to get into an actual settlement agreement. And so, that would be great if you did. And so, you have to consider how you're going to get that settlement agreement signed. If you have any technology like DocuSign or HelloSign, specifically right now, because of the pandemic, those have been helpful in getting agreement signed. And then also, you just want to think about what your responsibilities are. So, depending on if you reached an agreement, there's some follow up that's required, right? So, you have to make sure that any deadlines are met. If payment needs to be made to the opposing party or received, you want to make sure you calendar that you're either receiving or sending payments. you want to make sure that your mediator is timely paid. Some mediators require payment up front. Others, have grace extended to attorneys for us to pay timely, and so you want to make sure that your mediator is timely paid. I had a situation one time where my client actually mailed a check to the mediator, and my office mailed a check to the mediator, and I told that mediator that it's better that you're doubly paid and you can issue a refund than for you not to be paid at all. So you want to make sure that your mediator is timely paid. um, your mediator, if the case settles or not, is going to file a mediation report with the court. And so you want to make sure that that report gets filed as well. And so just any obligations that are required, you want to make sure that those are fulfilled. And so that I went through that a little bit faster than I expected, but now we kind of have this time for a question and answer session. So I'm happy to answer any questions that you might have. And I'm also happy to hear about, anybody that's kind of had like some really difficult mediations in the past. Maybe, if you can share your experiences as well. So I'll kind of open things up. And Lauren, if you can make sure that that people are able to unmute in order to ask questions, that would be great.
I have a question, Christy. Do you have a thought about whether the mediator should prepare the agreement or whether the attorney should?
So I think that it really doesn't matter to me personally whether the mediator prepares it or whether the attorneys prepare it. I have a slight preference for letting the attorneys prepare it, but I've done it both ways. Specifically with small claims disputes, oftentimes the mediator will prepare those. But when I go to mediation, I often will already have an agreement that's kind of drafted with just some blanks for us to fill in the event that the case settles, or just have an agreement, kind of a form document that I use. So I have a slight preference for the parties preparing the agreement, one of the attorneys, and then just kind of going back and forth. But even if the mediator prepares the agreement, I think that it's important for the parties to give their input. Um, and to that end, oftentimes what I will do is I will actually, like, let's say that the opposing party prepares the agreement. I will review the agreement with my client while I'm making notes as to things we should change. So I just think that it's super important that that you, as an advocate for your client, that you review the agreement with your client, that you are able to make any suggested changes that are necessary, and that your client clearly understands what they're signing before they sign it.
Do you have any advice for someone, for mediators who clearly recognize that one of the attorneys has come unprepared or doesn't generally practice in that field of law and has no clue what they're doing?
So I mean, I don't know necessarily that I have any suggestions regarding that, but if you think that someone is not prepared, what the way that I would handle it is I would not let that fact um, be something that interrupts the mediation. So what I'm saying is, if I think that the opposing party is not prepared, that they maybe don't understand some of the issues, then it might be a good idea maybe at one point. Like I don't think I would ever do anything to embarrass the opposing party per se, but it might be good perhaps to recommend to the mediator to say, hey, would it be okay for me to have a meeting directly with the other attorney, for example, and then perhaps share some case law or things like that during that meeting outside the presence of the actual parties. I've done that before. I have also just kind of used information, no matter what it might be, whether the person is unprepared or whatever the case might be, but you can use that possibly to your advantage. If you think that there's something that you can say or do that might result in being able to get the issue resolved. But I think the biggest thing is if you think that the opposing party is not prepared or not aware of all of the issues they need to be, I think that I would probably recommend having an independent meeting with that attorney during the mediation.
And would you think that the mediator would have that meeting, or do you think the best route to go would be the mediator calls an attorney conference and lets them educate each other?
Yeah, I would recommend that the mediator call the attorney conference. Absolutely.
Mm. How do you handle a mediator who's giving legal advice to your client when you're sitting there?
Yeah.
Nobody I know does that, of course, but just
Yeah. One of the things that I have, just as this is just a general way that I practice law, is just that I tell my client I will always tell them the truth. I say, look, I'm always going to tell you the truth, whether you like it or not. And my expectation is that you will always tell me the truth. Now, does that always happen? Not necessarily, but I think it's just like the basis of how I practice law. And so when I'm preparing my client for mediation, I tell them, I say, the opposing party is going to say some stuff that you completely disagree with. They might say some things that we actually agree with, but I will tell you whether I think that they have a valid concern or not. And so the same thing goes with the mediator. So a mediator will oftentimes tell you, oh, well, I think that this is an issue that's really going to affect whether, a jury can find in your favor, whatever the case may be. Well, what the mediator probably doesn't know, well now, and if I use you, you'll know. But what the mediator may not know, or what the opposing party may not know, is that I have this bond with my client that I'm going to tell my client whether I think that they're making a valid concern or not. And so if the mediator gives legal advice, I will oftentimes say, well, okay, can I speak to my client, alone? And when I'm talking to my client alone, I'll tell my client, hey, I think that what the mediator, is saying is true. Or I may say, I actually think that the mediator has a decent point regarding this, but I think that they're not considering that. So I think that it's my obligation as a person's counsel, to actually counsel them regarding any arguments that are made, including whether those arguments or legal opinions are from the mediator or the opposing party. So hopefully that's helpful.
Oh, I see that Keith has put a question into the chat. Let me read it to you. Whoop, where'd you go?
Sorry.
How do you feel about the mediator meeting in caucus with just the attorneys without the clients?
So that kind of goes back to one thing that I was mentioning. I think that attorney meetings, just the attorneys and the mediator, that they can be effective, especially if it's a really difficult situation. If whether you're dealing with difficult personalities, or if it's just something that's hard for the parties to understand, or if the parties are not prepared. Yes, I think that the meeting with the mediator and the attorneys can be effective. I just think that it's important that you communicate expectations to your client as well. So hopefully that's helpful. Does anybody have any other questions or concerns?
Well, Keith has a follow-up. Keith has a follow-up
Oh,
question. How does the attorney explain that to their clients?
The way that I explain it is I just try to be honest and transparent. So the way that I explain it is oftentimes to say, hey, that one of the reasons that we're here today is we're trying to come to some sort of, good faith resolution. And so all of us came here today, to try to get this matter resolved. I think it might be helpful for me to have a conversation with the opposing attorney, and it might you know, and I just try to be transparent in order to explain these issues to them, or, you know, because I think it'll help us try to get this case resolved, or I think that it'll help us move the numbers together, or whatever is going on. I just try to be transparent and explain it to my client. So hopefully that's helpful. Any
Good.
other questions?
Everybody's being shy today.
All right. But I do think that that, you know, the number one thing about handling difficult mediations, I think, is it just really starts with what you're doing prior to the mediation, how you're preparing your client, what expectations you're setting, and then just communicating with your client throughout the mediation. Because I've had mediations before where my client is the one that's, you know, kind of making things difficult. And so if that's, you know, if my client is the one that's kind of preventing us from getting the case settled, then I, as an advocate, will just, you know, kind of explain to them, like, make sure they understand the risk of moving forward, the strengths and weaknesses of our case, and, you know, give my thoughts about whether or not I think that, you know, settlement is in their best interest.
And there's a comment from Bob Pritt. I find that most attorneys are not prepared for court-ordered mediations. Do others have the same experience? I certainly do.
Mhm. Interesting. I mean, I think that we have to remember that our clients are paying us, regardless of if it's a court order mediation or whether you're using a mediator and paying them an hourly rate. Like, I think we have an obligation to be, um, you know, prepared. And so, would I put together like a mediation presentation and a long mediation statement for, let's say, a small claims case? Probably not, but I would still have taken the time to think through the issues that I'm recommending today. And so I think we have to remember our obligation to our clients.
That's a good point. There's a comment from Keith Grossman. I agree. I think the process of preparing a mediation statement helps attorneys be more prepared. And then there was another question from Keith. What role does a paralegal play in helping prepare the client for mediation?
Well, I think it depends on how you you and your paralegals work together. Personally, I have had a paralegal put together a draft mediation statement before. If the paralegal knows the facts of the case, and is competent in that way that she could at least give you a starting point, by all means. I have used my paralegal in that way. Especially, you know, whenever you have a paralegal that's really knowledgeable with a lot of experience, you can have them take the first draft of the mediation statement. And so that's one way that you could use your paralegal. Or another way would be in helping you gather documents that might be helpful. Like if you have any documentary evidence that you might want to make sure you're able to use during the mediation, you know, gathering documents. But for me and the way that my office works, I actually have my paralegals help out with the mediation statement. If it's a case that maybe my paralegal doesn't know a lot about, then I'm still old school in that I can dictate. You know, go ahead and, you know, record or to have the paralegal transcribe, you know, the facts and that sort of thing. So however you and your office works together effectively, I say definitely use those paralegals and legal assistants effectively.
And then there's a follow-up comment from Bob Pritt where he says, a benefit of court-ordered mediations and non-binding arbitrations is it does force attorneys to prepare. So
Absolutely. I certainly agree.
okay, anybody else want to weigh in on their experiences or with a question of Christy? Well, it looks like we are concluding our time, unless Christy, do you have any final wrap-up comments?
The only thing that I would say to wrap up is just as attorneys, we just always have to remember our obligations to our clients. Recently I had a client tell me that they were making like a really um, hard financial decision in order to be able to afford an attorney. And so you have to remember that your clients are making a sacrifice possibly in order to have counsel. And so we do have an obligation to be prepared. The other thing is that our clients are looking to us to guide them through the mediation process. And so just remember that the way that you respond can have an impact on how your client responds. And so I think that those are the most important things to keep in mind in being professional during mediations. So thanks again for having me. I really hope that this information was helpful to you all.
Well, I do have one last question. In your introduction, you indicated that you do church law, and I went to a little workshop given by the Dispute Resolution Center on church-based mediations. In your experience, is that an area where mediators can be helpful?
You cut out a little bit at the end, but you said, is that an area where?
Where mediators can be helpful?
Oh, absolutely. So one interesting thing that that deals with the area of church law as a practice is that almost all churches have some sort of document that governs how they resolve disputes. So oftentimes they'll have a constitution or bylaws, or sometimes they have like I've seen churches call it like a book of discipline. And oftentimes they will require that mediation take place prior to a case being litigated. And sometimes I've even seen some churches say that attorneys are not allowed to attend the confidential mediations of the church. So it just depends on what type of church it is, what the what their governing documents are and that sort of thing. But I found that mediators can definitely be helpful in resolving church disputes, because oftentimes churches do not want a case in court. They want to resolve it independently. And so mediators can definitely be helpful in that way.
And would it be a dispute between a minister or a rabbi or a priest and the church, or would it be an internal congregation issue, do you think?
Normally, those would be for internal congregation issues. So everything from a minister being, asked to step down or something like that, or if they're having issues with an actual member, most of the time that church's governing documents are going to govern how that's to be resolved. But oftentimes it involves some sort of meeting or mediation. So mediators can be helpful.
Hmm. And is there a way a mediator can market themselves to churches or synagogues or some other type of religious organization?
Yeah, absolutely. I mean, I think that it starts with just like your online advertising or reaching out to churches and independently. Like for myself, I found like I really thought about it. I'm like, well, look, a lot of the stuff that I deal with as it relates to business law is it transfers over to churches as well. And so I kind of I had a couple of churches that had reached out to me for legal advice, and I just started marketing myself with as church law. And I found that there's not a lot of attorneys that have marketed themselves, but churches need help just like every other type of entity. So it's been really effective, and I would encourage mediators to do the same.
Thank you. That's a great point. Keith, you had indicated in the chat that you've done some synagogue mediations. Can you share with us some of the not the details necessarily, but kind of the types of issues that come up?
These were two situations between a board of directors and a rabbi over contract disputes, and they were just very difficult conversations, very sensitive conversations. There were relationships, positive relationships with some board members and negative relationships with other board members, and they were very challenging.
Was it challenging because the board members weren't on the same page about their thought process?
There was that, and then the ones that have a positive relationship with the rabbi are, very emotionally attached to the rabbi side, but are also looking at it from the perspective of what's best for the synagogue. And so I think internally there's some conflict that some of them have as well.
Did you find, Keith, that you had credibility with all the members, or did it get personal with you as well?
Well, I knew none of them coming in, but my credibility came from the fact that I am a mediator, that I teach mediation and dispute resolution, and that I am a former president of my own synagogue.
Okay, got it. All right. Anybody else have any comments or questions other than the comments in the chat saying, Christy, you did a great job. Very nice, very, very nice work. Yep. And Lauren says, big thank you to Christy. Well, let's wrap up at this point. Once again, this is the ADR practice section. You're probably here because you are on the mailing list. If you're not on the mailing list and you wish to be on the mailing list, please send me an email, very informal. I promise I won't sell your email because first of all, I won't. And secondly, I don't have the brains to do that kind of weird stuff anyway. We have some great presentations coming up this fall, and Christy's recently had a baby, and if you call her up and ask her, she may show you some baby pictures of that wonderful child she had. But in the midst of balancing her home and work life, we prevailed upon her to do this presentation today. So I want to say on behalf of the ADR practice section and the whole board, we really appreciate your input and your thoughts in your presentation.
You're very welcome. Thank you so much for having me. Have a great day, everyone.
Okay, and we're concluding at this time. Thank you.